What is an insolvency practitioner and what does an insolvency practitioner do? Have you ever heard the term insolvency practitioner? If not, you're not alone. However, knowing who they are and what they do is important if you own a business that's struggling financially and has become insolvent. You will need to seek their advice as early as possible. In this video, we'll explore what an insolvency practitioner is and what they do when a company is insolvent. An insolvency practitioner is a licensed professional who helps individuals and businesses manage financial difficulties. They frequently act as a mediator between debtors and creditors and work to find a solution that satisfies all parties involved. They can take various formal appointments under the Insolvency Act, such as Liquidator or Administrator, or Supervisor or Receiver of a company, or Trustee in Bankruptcy, or Nominee or Supervisor of an individual voluntary arrangement of an individual. Note that some insolvency practitioners only specialise in corporate insolvency matters rather than personal insolvency, and vice versa. So, what does an insolvency practitioner actually do when a company is insolvent? Typically, they will 1. Review the financial situation. Insolvency practitioners will review the financial statements, cash flow forecasts, and assets of the company to determine the best course of action. 2. Communicate with stakeholders. Stakeholders encompass all individuals or groups who have a vested interest in the business. They include the directors, investors, lenders, employees, customers, and suppliers. In a formal restructuring, the insolvency practitioner will communicate with relevant parties and may need to negotiate payment terms so that solutions can be formulated. 3. Develop a plan to repay debts. Insolvency practitioners will work with the company's management team to develop a plan to repay debts. This can include selling off assets, restructuring the business, or negotiating with lenders for more favourable payment terms. So, it's not always the case that a formal insolvency appointment is required. Indeed, an IP may act solely on behalf of one or more stakeholders in larger restructurings. For SMEs, the most common type of insolvency appointment taken by an IP is as liquidator of a company. Here's what an IP will typically do. Prior to appointment as liquidator, they will provide initial advice to directors, help directors prepare a report and statement of affairs, which is issued to creditors, prepare the necessary paperwork to ensure the correct legal procedure is followed to place the company into formal liquidation, i.e. board meetings, shareholders meetings, and creditors meeting. Following appointment as liquidator, the insolvency practitioner will notify creditors and relevant authorities, realise company assets, agree creditor claims, distribute any surplus funds in the correct order of priority, investigate the reasons for failure, undertake various other reporting duties to creditors, government authorities, and Companies House. If there are sufficient asset realisations, a liquidator will seek approval from creditors for payment of remuneration. Becoming an insolvency practitioner is not easy. They are highly trained professional individuals who are licensed by the government to perform their duties. Many IPs started out life as qualified accountants before embarking on a career in insolvency. They have a deep understanding of the law and the financial world and are committed to helping businesses and individuals get back on their feet. They play a vital role in helping businesses and individuals navigate financial difficulties. When a company is insolvent, their expertise and knowledge can make all the difference in ensuring that everyone involved receives a fair and equitable outcome. Thanks for watching, and if you have any questions, feel free to leave them in the comments below.